I am Charlie Egerton. I am a partner in the Dean Mead law firm. I have been practicing as a tax attorney for over 45 years, and one of my specialties is in partnership taxation. And I want to talk to you today about a major new change that has occurred in the partnership arena. And one of my specialties is in the area of taxation of partnerships, and that includes entities that are partnerships under state law, as well as entities that are treated as partnerships for federal tax purposes, such as limited liability companies, which have become very popular in recent years. And the reason that I'm before you today is to let you know that a major radical change has occurred by reason of an action of Congress, a new law that was passed at the end of 2015. It was part of the Bipartisan Budget Act of 2015. It was signed by President Obama on November 15th, 2015, and was corrected, or a minor change or two were made to that bill in December of 2015. So it's a brand new law, and what it does is it radically changes the procedures in the event that an IRS audit takes place of a partnership. And this new law applies to all taxable years of the partnership that begin after December 31, 2017. If you're a calendar year partnership, in other words, that means 2018, which is just around the corner, and all subsequent years. And you should be aware that the reason that this change in law took place was that Congress and Treasury were convinced, and it is without a doubt true, that partnerships and their returns were largely going unaudited, even though close to a third of the business that is conducted in the United States today is conducted through pass-through entities, which include tax partnerships and S corporations. Partnerships accounting for perhaps more in terms of dollar than S corporations. These new provisions do not apply to S corporations. They apply to every entity that is treated as a partnership for federal income tax purposes. So if you are a partner in an entity that is treated as a tax partnership, you need to be aware of these new changes. These changes really, and I'm not exaggerating to say it is a sea change on what happens when the IRS institutes an audit of a partnership. And to give you an example, at the present time, if the IRS does audit a partnership, and they audit very few of them right now, a notice is given to a partner who is designated by the partnership as the tax matters partner. At the same time, notice has to be given to all so-called notice partners, which are generally anyone over a minor amount, 10% or so interest in the partnership, is given a notice of this audit, and they have a right to participate in any ongoing audit procedures, including taking it right on through to administrative appeals and up into tax court or federal district court or the federal claims court. What's happened under this new bill is that we now have a person who is designated as the partnership representative. And that partnership representative has substantially more authority than the old tax matters partner. In fact, that partnership representative, is the party that has sole authority to deal with the IRS throughout the audit in agreeing to any matters such as an extension of the statute of limitations, a settlement of a proposed tax adjustment, a decision to file a case in tax court, a petition, to challenge a tax deficiency, or to institute a refund action in the federal district court or the claims court, and to post a bond that is now required with Treasury as part of any federal district court or claims court matter. Under these new rules that take effect for calendar year tax partnerships on January 1, 2018 and go forward. All of us are familiar with what happens when a partnership files a tax return. Generally, it doesn't pay tax. the income, the loss, deductions, credits, and so forth flow through to the individual partners, and they, in turn, pay tax. And under the current rules that are applicable until these new rules kick in, what that requires is the IRS, if they're going to try to do an audit of a partnership, they have to first focus on the partnership, make their determination, and then they have to pursue any proposed adjustments out to the individual partners. That's no longer the case under these new provisions. What happens there is, if, for example, the IRS is auditing a 2018 tax return for partnership XYZ, then they deal with the partnership representative. That partnership representative perhaps is dealing with the IRS in 2020 or 2021 or even later. And if the partnership representative agrees with the IRS that an adjustment is due and a tax of, let's say, $100 has to be paid, instead of pursuing through to the individual partners to collect that, the general rule of these new provisions is that tax will be collected from the partnership in the year that the adjustment is agreed to and finalized. Radically different result and procedural result than what we have under current law, and somewhat inconsistent with the manner in which Subchapter K, which is the part of the code that deals with partnerships, has provided for years. It doesn't change the pass-through, but what it does is it changes the whole method of collecting, assessing and collecting the tax. And in determining whether the statute of limitations is still open so that the IRS can challenge, you look solely at the partnership's statute of limitations. The statute of limitations of the individual partners are irrelevant. And when an adjustment is pushed through to a partner, for example, if the partnership issues a K-1 to a partner, even before an audit takes place, that is deemed to be correct. And unless you file a special notice with the partnership and with the IRS, you have to report your income consistent with what's reported on that K-1. If you don't, it's treated as a mathematical error and can be automatically assessed by the IRS. Never been able to do that before. That's part of the new provisions. How is the tax deficiency to be determined under these new rules? Well, the general, or what we refer to as the default rule, it will apply unless either you're eligible not to have these rules apply to you, or you elect something called a push-out election, which I'll explain in just a moment. This is what happens. The IRS issues a proposed administrative adjustment. The partnership then has 330 days in which to contest that, to provide additional information to the IRS, to do anything they can to basically ameliorate or lessen, mitigate the effects of this proposed adjustment. If at the end of 330 days nothing has changed, then what the IRS does is they'll take, let's assume that they've determined that $100 income was not reported, net taxable income. Either the income wasn't reported or deductions were improperly claimed, whatever the case may be that gave rise to this. They'll then go through and make an allocation of that and determine that all of the partners are in the maximum marginal rate bracket and compute a tax that is owing. The partnership has an opportunity to show that if you have some partners, for example, if one is exempt from tax, it's a tax-exempt entity, or others are in a lower tax bracket, you can, during that 330-day preliminary period, provide evidence to the IRS, and they should reduce the tax accordingly. But it's an imputed, rough justice type of calculation. If it becomes final as proposed by the IRS, the tax obligation is imposed on the partnership for the year that the adjustment is finalized. Now, keep in mind that this may be 2, 3, 4, 5 years after the year that gave rise to this tax liability. We might have major changes in the composition of the partners in the partnership. Partners A, B, and C may have either died, passed it on to their estate, number 2, sold it, to a third party in accordance with the transfer provisions of the partnership, or gifted it to a trust or to a family member or whatever. But the composition of the partnership in the year in which the tax obligation is imposed on the partnership and collected from the partnership, we may have different partners than the people who were partners in the partnership for the year that gave rise to that tax liability. Is that fair? Well, I think most people would say no. So what can you do about that? Well, you're going to have to change the terms of your partnership agreement if you want to do equity there, in effect, impose that obligation on those persons who were partners in the year in which the tax was underreported for one reason or another. You're going to have to draft that and have that in there. In the absence of that, those who are partners in the year that everything gets finalized are the ones who are going to bear the burden directly or indirectly, because if it comes out of the partnership pot at that time, the value of their interest is diminished. What can we do now to deal with this? And I will tell you that we don't fully understand all of these provisions. They were just enacted. Neither Treasury nor the IRS has had the opportunity to provide administrative guidance on this, and they are working full steam. I just came back from a meeting of the American Bar Association tax section in Washington, and we had all of the major people from the national office there. Number one, soliciting input from us on what provisions they need to issue guidance on first, and secondly, trying to jointly work through these provisions and figure out how they should apply and what kind of administrative guidance should be given. So neither the IRS nor taxpayer representatives at this point really have their hands around this. And as a matter of fact, there are some major glitches, I think, in the statute, one of which may be that Congress inadvertently, I believe, left out a provision to get a refund if you've overreported your income in an earlier year when an audit is taking place. So that's something hopefully Congress will address and remedy. But I'm giving you these as just simply illustrations that we are dealing with this law in its present state, just trying to read the literal words of the statute, much of which delegates to the Treasury and the IRS authority to issue rules and to fill in the blanks in some of these things. So what are we recommending that people do now? Number one, be aware that this is coming and it's coming soon. And draft your agreements. And we are already drafting new partnership agreements and new operating agreements for limited liability companies to deal with these provisions to the best of our knowledge at this time. The most important thing, I think, is you're going to have to really think hard about who should be the partnership representative. Unlike current law, before these new provisions kick in, this does not have to be a partner or a general partner, which is a requirement under current law. It can be someone who is not even a partner, provided that that person has a substantial presence in the United States. But that person has absolute authority to deal with the IRS on behalf of the partnership. You want somebody that you have confidence in to play out that role. And you want to provide in your agreement that if you're not happy with that person, or that person otherwise becomes distracted, disabled, dies, whatever, you need to be able to quickly remove and replace that person because you've got to have somebody that you're confident in serving in that role. Secondly, because this person has carte blanche authority in representing and making decisions on behalf of the IRS and on behalf of the partnership, in dealing with the IRS, you need to impose some contractual restraints on that authority. And this is vis-a-vis dealing with the partnership and among the partners. For example, you should probably put in there that the statute of limitations which the IRS, particularly if they're running short on the period of time for statute of limitations, they'll ask for an extension. The partnership representative has the authority to do it. You can, and perhaps should, put in there that that statute should not be extended without the consent of partners holding a majority, at least, of the partnership interests. You can impose, you can make it a supermajority or a unanimous, whatever you feel comfortable in doing, but you need to deal with it. Entering into a settlement with the IRS whether it's as a part of the audit, whether it's at appeals, or whether it's in court. That person, that partnership representative, I would submit to you, should not be permitted to unilaterally make that decision without the consent of partners, again, holding either a majority, supermajority, whatever you're comfortable with. And in order to get anyone to agree to serve as a partnership representative, because with that authority comes an awful lot of responsibility and the threat of claims by one partner, right or wrong, that person did not make a proper choice. You need to provide indemnification provisions, I would submit, in there, that unless that person, number one, violated contractual restrictions, such as you can't extend the statute without the consent of a majority, and he goes ahead and does it, or number two, if he did something with a wrongful intent, something major wrong, and perhaps a self-interest or whatever, although if that partnership representative is himself a partner, he can certainly take into account his own situation in making that decision. But if you want to get someone who will agree to serve in that capacity, you're going to have to give adequate indemnification. At some point in time, too, knowing the insurance industry, they'll probably come out with some kind of partnership representative insurance, but at this point in time, there is no such insurance. So you want to deal with it that way. Another thing you want to do is, if in fact your partnership is eligible to opt out of this whole system, in other words, you have fewer than 100 partners, and by the way, it's not actually partners, it's K-1s that are issued, and that can be quite different if you have transfers of partnership interests in the interim. So it may well be less than 100, but if you're otherwise eligible, you have, let's say, 10 or 15 partners, none of whom are trusts or partnerships, you have to elect out of the regime each year. You may require the partnership representative, or you may require consent of, or upon direction of partners holding at least some percentage of the partnership interest, that you will opt out. Thirdly, there is another option that is available to you, and I haven't mentioned this yet, and it's what we call a push-out election. That effectively can be elected if you have an audit, and the IRS then considers all of your evidence and so forth and issues a final proposed partnership adjustment. Then you have 45 days after that to push out the tax liability associated with this, in effect issue revised K-1s to all the partners who were partners in the year that gave rise to that audit. And I think most people, when they think about this, are probably going to prefer this route. So that those partners and the partners who were there in the year that gave rise to it will end up having to pay the tax. You can do that, but again, it's the partnership representative that makes that decision. So you want to provide in your partnership agreement that you can direct the partnership representative to make that election if you're otherwise timely and give that instruction. All of these things are to say that even though we have limited knowledge right now, it's going to have such a major impact on all entities that are treated as partnerships for federal income tax purposes, that everybody, whether you're starting a new partnership or you already are part of a partnership, everybody needs to immediately focus on setting up provisions, assuming that these new rules will apply, anticipating the problems I've already mentioned to you, and I'm sure a lot more will come to light as we wrestle with these provisions and as we get more administrative guidance. But it's not something to just be put aside and worry about it in a couple of years, or actually it's less than a couple of years. It's something that needs to be addressed now, and then probably readdressed as we get more information and more regulatory guidance, and Congress may or may not act to fix some of the glitches there. But don't put this off. We encourage everyone who is a partner in a partnership to deal with these matters now. Let's get together, let's talk it through, let's consider our options, and then design a provision that will satisfy your desires and the desires of your partners.